What is everybody? Welcome back to Truth and Transparency, Idaho 4 investigation timeline and deep dive. Um, we have a lot going on. It's also Shanna Gardner. We're going to talk about that because we have a Frank's hearing coming up, or that they're asking for one. So take a look at this. Let's compare some shit. Let's talk about some shit here. All right. We have a trial set for the beginning of September. So let's see here. It's May. Okay, May. So you have what? May, June, July. They're doing jury selection August 10th. Okay. We got so many bombs to talk about. Alex Murdoch is going to get a new trial. Richard Allen better be getting a goddamn new trial. But Birdie has WSU mom on the live. Oh, that's good. Good for Kim. Kim knows where to reach me. We used to talk all the time. It's interesting that she's coming back around. We'll have to see what she has to say. But we need to talk about this. Let's see how Jose Baez went about asking for a Frank's. Just filed 2 weeks ago. The state handed detectives a skeleton key to Shanna Gardner's entire digital life. Every email, every text, every photograph, every search query, every location record, every deleted file, and called it a search warrant. It was not. A search warrant is a precise instrument surgically authorized by a neutral magistrate upon a showing of probable cause, carefully limited to the evidence of a specific crime. What was issued here were general warrants, blunt instruments of the sort that prompted the framers to enshrine in the Fourth Amendment in the Bill of Rights in the first place. As the Supreme Court has reminded us, judges are obligated, as subtlers and more far-reaching means of invasion of privacy have become available to the government, to ensure that the progress of science does not erode Fourth Amendment protections. Well, we've seen we're no stranger to Carpenter verse. That's what they used, okay, in the Idaho4 case. This court should honor that obligation. The 3 warrants challenged here for Miss Gardner's iPhone, so her iPhone, her iCloud, and her Google account are constitutionally defective on 2 independent grounds. The affidavits supporting them failed to establish probable cause, and the warrants themselves are not particular as the Fourth Amendment requires. All evidence obtained pursuant to them must be suppressed. I knew this was coming, but I wanted to know how. And here they chose to wait, and they chose to do their depositions. Jose Baez, Diane Manatchi, like this is, so they've done depositions. And now they're saying, hey, we want a Frank's hearing. We're going to be suppressing shit, but we also want a Frank's hearing. And so I'm like, okay, I'm here for it. So this is the factual background. And I'm going to show you guys a little secret here. Take a look at this. Let's see if you can see this. You see all those case files back there? Look at all those. Oh, you know how long that goes? All the way across the room, creating a sick studio over here. This is what I've been working on. Okay. So let's go back over here. All right. So this iPhone warrant on February 22nd, 2023, the court issued a warrant authorizing law enforcement to search and seize the entire contents of Miss Gardner's Apple iPhone 13 Pro. This would have been almost a whole year, okay, after the murder of Jared Bridegan. Okay. So, I want to say it was February 13th. Wait, is it? Okay. All right. So the supporting affidavit was submitted by Detective Jason Lamont. The iPhone warrant authorized seizure of 20 categories of information, in each instance described in its broadest possible terms using any and all without restriction. By way of example, it authorized seizure of any data related to user logins and passwords and any communication accessed, written, sent, or received or deleted, categories boundless in both time and subject matter. The warrant contains no date restriction of any kind and no limitation tethering the categories of data sought to the charged offense. This is how they got those text messages about funeral potatoes. This is crazy. This is crazy to me. Although the iPhone affidavit set forth extensive allegations of probable cause against Ms. Gardner's co-defendants, it provides scant allegations against Ms. Gardner herself. Of the allegations that do concern her, nearly all describe conduct occurring after the murder. The only pre-murder allegation are that Miss Gardner was previously married to the victim, Jared Bridegan, and is presently married to and separated from co-defendant Mario Fernandez Saldana. The remaining warrants repeat substantially the same factual allegations. The iPhone affidavit contains a section titled Information regarding the function of cellular devices supporting the obtaining of data in its entirety, in which Detective Lamont describes the vast quantities of personal information stored on modern cell phones and asserts that the entirety of the device is necessary because it may convey communications between parties and identifies suspects, co-conspirators, associates, witnesses, and other individuals who may have involvement or knowledge of crimes. This is what I said from the beginning. I was like, so let me get this straight. Just being married and divorced from Jared Bridegan automatically made Shanna Gardner open season on all of her shit. Like, that's probable cause. Probable cause is that you were married to him and you got divorced. And now he's murdered. He's dead. He was shot. So that's probable cause for us to go and get your devices. Like, that can't be real, right? Oh, you guys were arguing about custody. Well, let's just see how this plays out because I'm just curious. Because Jennifer Drake, the wife of Brian Drake, who was murdered, well, she was conveniently supposedly on the phone with him, but he really wasn't killed at that time. They just made it seem like he was killed at that time. They didn't even bother like doing one search warrant after talking to her, like for her anything. They never went into Brian Drake's house. They never obtained any of his computers, the family computers. I mean, nothing. And yet she's over here dialing up life insurance right after. I mean, so again, this is about us learning this. So again, let's see how Jose Baez goes about this and his team versus how Ann Taylor went about it. Now, the iPhone affidavit contains section, so that's what I just said, in which Detective Lamont describes the vast quantities of personal information stored on modern cell phone and asserts that, okay, so I said all that. This generic rationale, untethered to any specific crime, like, what are you doing? Like, exactly, like, what crime are we, like, what did she do? Okay, you know that she wasn't the shooter. For any specific allegation against Miss Gardner or any specific category of evidence was the sole justification offered for seizing Miss Gardner's entire phone. It was accepted by the courts. Like, yep, that's fine. It's not. How is that? You guys, I get it. I get it. Okay. Her ex-husband was killed. I understand that. Okay. But like, why do we have why why do we have any rights? Okay. I just don't understand. Like, judges are just doing whatever the fuck they want. Magistrates, it's like if you just go and hand them a piece of paper, they sign it, doesn't matter. This needs to change, right? The warrant was signed February 2nd or 22nd, 2023. The return was made May 26th, 2023. That is insanity. You understand that, right? Normally you serve a search warrant and then you get it back, and then this would be happening like el pronto y pronto from this date. Look at this. The iCloud warrant on April 3rd, 2023. The court issued a warrant authorizing law enforcement to seize the entire contents of Miss Gardner's iCloud account for the period of November 1st of 2021 through March 27th of 2023, the iCloud warrant. The supporting affidavit was submitted by Detective Christopher L. Johns, who's a complete idiot. The iCloud warrant's disclosure provisions, paragraphs 1 through 9, demand without subject matter limitations the entirety of all emails without like nothing. So like we are getting all emails, all iMessages, all iCloud backups, all Apple and third-party app data, all photos, all videos, all location data, all FaceTime logs, all transaction records, all device identifiers, and quote unquote, all files and other records stored on iCloud. A separate provision limits the information to be seized by law enforcement to evidence of violations of Florida statute section premeditated murder and child abuse. But this is only after Apple has delivered the entirety of the account to police. What? A separate provision? So this happens afterwards? But this only happened after Apple had delivered the entirety of the account to the police? Did they put this provision in that, oh, hey, this is in because it's about premeditated murder in this? The iCloud warrant acknowledges that the requested time frame of 16 months is longer than would be typically requested. It's like says it in there, justifying the expansion on the ground that this is a contract murder for hire, and the detailed planning, execution, and cover-up. Detective Johns did not, however, seek a warrant for murder for hire, nor did the issuing court find probable cause for that offense. What? You gotta be shitting me. The warrant was signed April 3rd, 2023. The return was filed May 1st. Again, that's a long time. Now we have the Google warrant affidavit. Also on April 3rd, 2023, the court issued a warrant authorizing law enforcement to seize any and all files and or content associated with Ms. Gardner's Google accounts from November 1st, 2021 through March 27, 2023. The supporting affidavit was also submitted by Detective Johns. The Google warrants disclosure provisions, paragraphs 1 through 24, demand without subject matter limitation the entirety of all Gmail messages, all Google Drive contents, all Google Docs and Sheets files, all Google voice recordings, all Google photos, all Google Sites files, all Google Plus data, all Hangouts communications, all web browsing history, all search query history, all click history. Where is that? All analytical data, all geolocation data from every device ever logged into the account. All app download history, all third-party application connections, all deleted data, and all account access records. Like the iCloud warrant, a separate provision limits what may be seized to evidence of the charged offenses. Again, this is only after Google has delivered everything to law enforcement. The Google warrant further authorizes seizure of all evidence, which tends to show a crime has been committed. Any crime, not merely the offenses for which probable cause was found. The return was filed July 14th. What? Look at this. That's insane. What? I'm like so confused here on why this would take this long to return this. Damn. All right, let's see. On August 17, 2023, the grand jury returned an indictment charging Miss Gardner with first-degree murder of count 1, conspiracy to commit murder, count 2, solicitation to commit a capital felony, and child abuse. Okay. The United States and Florida constitutions guarantee the right of the people to be secure against unreasonable searches and seizures and mandate that warrants issue only upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the things to be seized. These provisions exist to prevent precisely what occurred here: the issuance of general warrants enabling a general rummaging through the life of anyone suspected of a crime. Stanford versus Texas. I didn't see this being I gotta go back and check Brian Kohlberger's stuff, but I want to take a look and see if that was ever used. The warrants challenged here are constitutionally defective on two independent and reinforcing grounds. First, the supporting affidavits failed to establish probable cause as to Miss Gardner's personally and as to the specific places to be searched. Second, even assuming probable cause, the warrants themselves are not particularized as the Fourth Amendment in Article 1, Section 12 of the Florida Constitution requires. The affidavit failed to establish probable cause. Probable cause is not a bureaucratic formality to satisfy by reciting generic investigative boilerplate. Thank you. Finally, someone said it. Thank you. You cannot just recite these stupid fucking things, copy, cut, and paste, and put boilerplate fucking, here's your template to fucking write up a stupid search warrant, okay? Fuck all. But guess what? When people are defending somebody, when they try to go about like explaining this, they always suck. Here, oh my God, it's just so amazing just to see this perfectly stated sentence. Probable cause is not a bureaucratic formality to be satisfied by reciting generic investigative boilerplate. Period. That's what we've been seeing in all of these cases. Because what I've been saying to everybody is you can create circumstantial situations for anybody and everybody to be guilty. I mean, you can literally do that because of the way that you can form and curate a case against anybody circumstantially. It is a substantive constitutional requirement that protects the innocent and the guilty alike from the unchecked exercise of state power. A search warrant affidavit must establish two distinct elements. First, that a particular person has committed a crime, the commission element. And second, that the evidence of that crime is likely to be found at the specific place to be searched, the nexus element. This is where they try to tell, like with relevance and when you want to use third party culpability and shit like that, a judge is like, what's the nexus here as to how you're going to bring in, like Ron Logan? Well, there's a nexus there. Okay, but Richard Allen's attorneys, they just, I don't know, got brain dead. And when doors were being opened and when you could have asked certain questions, it's going to automatically open up the floodgates. Okay. You have to call certain people to the stand. Anyways, I would totally agree. And people also think that Shanna Gardner was working like a ton of jobs. Wait till that shit comes out. Okay. Anyways, both elements must be established by specific articulable facts, not inferences, speculation, or an officer's generic training and experience. Bingo. I hate that. I hate that term. Based on my training and experience. What training and experience, motherfucker? What? Detective Johns, this is your first fucking homicide. Okay, this is the first time you've been on your own. What training and experience? Please tell me, boy. Get the fuck out of here. Using that bullshit. Upon my training and experience. Well, that just allows me to then just bring in who the fuck trained you and just destroy them because it's relevant, because this is how you were trained. So if you're going to allow this shit, then you're going to allow me to destroy his person that trained him. The three affidavits here fail on both counts. So A is the affidavit fails to establish a nexus between Miss Gardner and the crime. Now I wanted to see this because this is huge. Okay. To establish the commission element for premeditated murder, an affidavit must provide facts sufficient to support a reasonable belief that the named defendant premeditated and caused the death of the victim. The affidavits here do not come close. They allege no facts placing Miss Gardner at the scene of the murder, in contact with the alleged shooter on or around the night of the murder, involved in planning the route, or connected to the weapon used. Absolutely. It's insane. Because guess what? Henry Tennant isn't the fucking shooter. How about that? And you fucking strong-armed a black man and let him can say, yes, sure, I'll say that I did it. Because you threatened him with the fucking death penalty. Pisses me off. Thank God Henry Tennant has a lawyer. Atlanta, why isn't Brian or his family fighting for his innocence? How do you know he is or is not? His family or him? We have no idea if he is or he is not. So when you ask Atlanta, why isn't Brian? Where do you think that he's not? Now, the affidavits, plural, are replete with allegations concerning other suspects, Mr. Fernandez Saldana, Mr. Tennant, and Mr. Biggerstaff. But those allegations cannot be imputed to Miss Gardner by association alone. The law is unambiguous on this point. Proximity to a suspect, even intimate proximity, does not supply probable cause to search that person. Where the standard is probable cause, a search or seizure of a person must be supported by probable cause particularized with respect to that person. The fact that probable cause exists to search or arrest another person in the same household cannot be bootstrapped into probable cause to search the spouse. I love it. Bootstrapping motherfuckers. If Ann Taylor was as good as this team, we would have had a trial. We would have had a trial. But Ann Taylor is a fucking public defender who then made a mill, maybe more, then decided to start her own practice. You cannot do this. Look at this. Nice. Ann Taylor, I told you to watch this case, but it wasn't it wasn't developing fast enough. And then I told this case to watch the Kohlberger case because of this the AT&T timing advance. How come this case of a murder that happened in 2022 in February, how come they were able to get timing advance in 2022? That's what I thought. Okay. I'm going to take a look at that case right there. Presumptions of guilt are not lightly to be indulged from mere meetings. Wow, look at that. Going back in the cut. A hunch dressed in a marriage certificate is still a hunch. God. Oh my God. I told you what I think this is. I think the affidavit's reliance on Miss Gardner's marital relationships to the victim and to the co-defendant as their primary basis for suspicion is constitutionally insufficient. Thank you. I fucking love it. This is exactly what I fucking said. I said, what? We can just get probable cause nowadays because of, hey, that is her ex-husband and that's her husband. And now it's free reign of Shanna Gardner. Thank you. Fuck God. I don't even need to go to law school. This is common sense to me. There's just no way that that's accurate. You know, it's just all of the feels are wrong. And it's because it's not accurate. You can't just do that. God, fuck yeah, Jose. Fuck yeah, Diane. Fuck yeah, Patrick. But nobody should have to have lawyers like this. Like, nobody should have to pay $1,000 to $1,500 an hour for lawyers to actually know what the fuck they went to school for. I mean, I'm sorry, but if anything, like, there should be no public defender's office anymore. And when you decide to become a lawyer, it's like jury duty. Okay. Every so often your name is in the bag. And if you get picked, hey, it's your turn to represent somebody for free. That's what you take on. And when I say for free, no, you're going to get paid at the state wage. Okay. That's the type of shit that needs to happen. Across the board. Okay. God, love it. This is exactly what the fuck I said. I said, there is no way that this is grounds for probable cause. And they write it right here. Huh. Let me just fucking highlight that shit. Let's just have some margaritas. Fuck this shit. Let's get drunk. We'll still nail it. There it is. The affidavits failed to establish a nexus between Miss Gardner's accounts. Thank you. And the evidence saw it because they lied. Even where probable cause to suspect a person of a crime exists, a separate and independent showing is required. The evidence of the crime will be found at the specific place to be searched. There must, in other words, be a nexus. We all know what that word means, right? A nexus between the place to be searched and the evidence sought. Like, for example, you own a pool, okay? You're not going to go searching for a floaty to put on your kid Okay. In your neighbor's bedroom. Okay. That's just, there's no nexus there. Why would a device, a floaty device for your kid to swim in your fucking pool, be in your neighbor's bedroom? No, your shed, your garage. Those are the nexus right there. That's my example for that. There must be a nexus between the place to be searched and the evidence sought. Duh. That nexus must be grounded in specific articulable facts, not conjecture or inference from general propositions about criminal behavior. Exactly. And that's the whole thing that they did. It was unbelievable. The iCloud affidavit does not allege that Miss Gardner owned an Apple iPhone. Dead. I was saying this. Okay, because I said, what if you don't have an Apple phone? There's no such thing as the iCloud then. If you don't have an Apple phone. Okay. You like, what do you have an iCloud account? Like, what do you like? And if you have like, let's say like a Android, like what do y'all have? I have an Apple phone, so I have iCloud. Okay. So right here off the rip, the iCloud affidavit does not allege that Miss Gardner owned an Apple iPhone. Wow. Which you would need to have an iPad or any other Apple device at the time of the murder. Or at the time the affidavit was sworn. It does not allege that she used any Apple product to communicate about the murder. Oh my God. This is, do you see how this is written? Like, do you see how they're walking step by step to a judge to walk them to it? This isn't what Ann Taylor did. Ann Taylor was just assuming too much, is what it seems to me that she did a lot of. And it's like you can assume that they're gonna get it once you lay every step out. Because these judges, they just don't. I'm sorry, but they just don't. They went to school. To think that these judges have common sense, most nerds don't. Most people that are book people don't. Sorry, just it's the facts. So it does not allege that she used any Apple product to communicate about the murder. It does not allege that any specific communication document or record relevant to the charged offense was stored on her iCloud account. The logical foundation for the warrant that the iCloud account of a person suspected of murder will contain evidence of that murder is supplied entirely by inference, not fact. Booyah. Thank you. And this needs to change because it's no different than since our phones have become our home. Okay. It's no different than coming in my house. And if you want to search my office and go into my fucking filing cabinet right here, you think you can just have a search warrant for my house? No. And so people thinking that they can just go into these fucking phones and just get whatever they want is absurd. Is absurd. And you know who's to blame for this? These fucking prosecutors and these fucking judges. Because they know that it's been wrong. It's been wrong for a long time. Just go into someone's phone. Like if you take care of your mom or your grandparent or you have children and their health shit's in there, their health, all the portals and stuff. Get the fuck out of here that you think that you can just go in my shit. You can fucking touch your toes, motherfucker. Okay. The Google affidavit fares no better. No better, motherfucker. No better. It does not allege that Miss Gardner communicated by email, used Google messaging, maintained a Google calendar, or relied on any Google product in connection with the charged offenses. Maybe you should have used your little bigger staff. Okay, instead of being so secretive about this whole thing, and actually laid out, because everybody wants to do everything in secret, and make John Biggerstaff sit across the table from you, and you write in every little thing that you should have to actually get this, to get proper warrants, and to say her co-conspirator John Biggerstaff, while getting railed from behind by Mario with a strap on, they were talking about how they were going to commit this murder and how much they're going to get paid. Why aren't you writing all that shit? Yeah, that's what I thought. Fuck that. Fuck these people. Stifler and Nelson's, just so you guys know, the death penalty, they took off the table a long time ago. This was a death penalty case. Why do you think they took the death penalty off the table? Because they were losing their case every which way. They're like, we just need to focus on the case. We do not have time to file all these motions and deal with this death penalty situation and what it's all going to bring. But how we're going to make it look is that we're giving mercy. We're going to say mercy because fuck out of here. Please. I'm just curious to see how Judge Kite does her job. I cannot wait to see how she does her job. So again, the Google affidavit fares no better. It does not allege that Ms. Gardner communicated by email, used Google messaging, maintained a Google Calendar, or relied on any Google product in connection with the charged offenses. 2 full paragraphs are devoted to generic boilerplate assertions about how criminals generally use computers. This is exactly what Ann Taylor just could not articulate to the court. Ann Taylor, man, take this lesson right here. Like, as an athlete, we watched film of our opponents so that we could beat them, right? Wouldn't you want to learn from somebody like, fuck, man? If you're a lawyer out there, like, you have access to all of this shit because the dockets are public, motherfucker. Go look at a case that's similar to yours and see what these people are doing. Like, why wouldn't you? Just idiotic. because lawyers have complexes, that's why. But the good ones, the real good ones, I just don't think that they do. I think the real good ones have common sense, because this is just so common to me. This is common sense. And maybe, I don't know, maybe I'm just different, but this to me, it's like you're having an argument with your spouse and they're accusing you of cheating because you went to yoga. What? Not that you were out late getting plowed, having drinks on Cinco de Mayo, but that you were at yoga at 4:00 in the afternoon. Well, then I must be fucking somebody awful that doesn't have a job if they're able to fuck at 4. Or they must be loaded so they can just make their own schedule around my fake yoga schedule. It could be laziness, sure. Anyways, it's just, I agree with all of this stuff. Like, you cannot just say this. 2 full paragraphs devoted to generic boilerplate assertions about how criminals generally use computers. Assertions that would justify a warrant to search the Google account of virtually any criminal suspect in any case, just because you can say, when someone commits a crime, this is what they're going to do. Yep, go search. Ridiculous. This is precisely what the 4th Amendment prohibits, guys. Okay. Number 15 is the affidavit's reliance on the affiant's training and experience or opinions cannot fill this evidentiary void. We don't give a fuck, Detective Johns, what you've done to get your little badge in your little stars and stripes, okay? We don't give a shit. It does not change this void, which you're missing, this evidentiary void. Training and experience may inform the interpretation of specific facts that are otherwise established. They cannot manufacture facts. God damn it, this is amazing. This is worth its price in this document right here is worth every penny. However much money this document alone um cost to type up and make, the hours that went into prep this is worth every penny. Because it's just so true. And it's a hard, maybe it's a hard pill to swallow out there, but you just, sorry, but your training and experience, it doesn't fill this evidentiary void, and nor does your training and experience, I'm sorry, but you cannot just manufacture facts that are absent. Like, it's great. If Ann Taylor would have done something even just remotely similar to this, like, how'd you get to Brian Kohlberger, motherfucker? It's nowhere in that fucking probable cause affidavit, right? This principle was applied directly to digital device warrants in the United States versus Griffith. I think she mentions this, so I'm going to look up and see if Ann Taylor talked about this. Where the court held that a warrant to search a suspect's home for cellular phones was unsupported by probable cause because although the affidavit established probable cause to believe the defendant committed a crime, it offered no case-specific basis to believe he owned a phone or that any phone exactly would contain incriminating evidence just because you have a phone. You know, go find me video surveillance, okay, of somebody casing the 1122 King Road house using a phone on the phone at 3:00 in the morning. Show me this white vehicle. Give me something like that. Okay. It's just right. Dude, she's been there for a minute. And I've tried to give her so much grace, but I can't. Because if your client is saying that he's innocent, why would you ever advise him to take a plea deal? You would tell him to go to court even if you lost. We've preserved a ton of different avenues for you to appeal. Okay? That's why I have issue with Ann Taylor. The court rejected the government's argument that because cell phones are, oh, I don't even know that word. I'm gonna have to look that up. It is reasonable to infer that any suspect possesses one, noting that to accept such reasoning would be to invite general warrants authorizing searches of any property owned, rented, or otherwise used by a criminal suspect, just the type of broad warrant the Fourth Amendment was designed to foreclose. The next sentence is just priceless. The same principle defeats the nexus showing here. What? Yep, pretty much. The heightened concern for particularity and nexus is especially acute when the target of the warrant is a cell phone or cloud-based account. As the Supreme Court recognized in Riley v. California, these devices and accounts contain the entirety of a person's private life, family communications, health records, financial information, location history, political views, and intimate personal correspondence in quantities and detail that dwarf any physical search. Amen. It would be a particularly inexperienced or unimaginative law enforcement officer who could not come up with several reasons to suppose evidence of just about any crime could be found on a cell phone. Exactly. Thank you. I know, right? You guys, anybody that has an issue with this needs to say why. Out there would say, like, Anybody that thinks that search warrants like this should just be blanket and yep, your husband was murdered or your ex-husband was murdered or your sister was murdered and it's just oh yep, that's probable cause because of your relation because of your hey, you're related to that person or you were married once or you're married now that's automatic that we have to do whatever the fuck we want. We have probable cause to suspect that you committed this murder or paid somebody to. How? Where? How? What are you talking about? You can't just do that. You can't just do that. And then you definitely can't go to court and lie about some fucking 2015 text messages about funeral potatoes during when people get divorced and they say shit and then say, "Oh, we're going to use that, 7 years later." And just say that, "Yep, this is Shanna Gardner shopping for a hitman." Do you got somebody that can do you know any magicians that you can make him disappear? The fuck? And then everybody that goes through a divorce is basically like you're signing on the dotted line that we don't ever need probable cause to go into any of your shit once you become divorced and anybody is killed. If that was your person, free reign. So stupid. Um For this reason, probable cause to search a cell phone or cloud account must be specific and concrete, not vague and generalized. The affidavits here fail that test. The warrants are general warrants violating the particularity requirement. And this is what Ann Taylor was trying to say. But I don't know what she did, but, blah, blah, blah. Even if the affidavits had established probable cause, they did not. The warrants themselves are unconstitutional. The Fourth Amendment and Article 1, Section 12 of the Florida Constitution requires that a warrant particularly describe the things to be seized. This requirement is not a technicality. Oh my God, I'm gonna die. This is amazing. This is amazing. God bless America. You remember what the feds told Steve Gonsalves? You think we're gonna fucking lose on a technicality? Our rights are not a technicality. Okay? They're our rights. Let me just repeat this for you guys. This is amazing. So, the Fourth Amendment and Article 1, Section 12 of the Florida Constitution require that a warrant particularly describe the things being seized. Okay? This is a requirement. Okay? This requirement is not a technicality. It is the mechanism by which the judiciary maintains control over the executive's search power. Thank you. Holy shit. You would think that a lawyer does not know how to put that sentence together. Because had Ann Taylor been able to articulate any of this shit, maybe her client would be in a different situation. Thank you. Somebody go ahead and take somebody should frame this shit. As to what it is to be taken, nothing is left to the discretion of the officer executing the warrant. Wow, this is so good. The particularity requirement is fulfilled when the warrant identifies the items to be seized by their relation to designated crimes. This is why people aren't being specific anymore. Being specific would be, I am looking for text message communications between Shanna Gardner and Henry Tenen, Shanna Gardner and John Biggerstaff, Shanna Gardner and Mario Saldana, plotting and planning the murder of Jared Bridegan. Capiche? Where is that? Where is that in the search warrant? Isn't that what you're looking for? So therefore, it should just be messages, what? With those three people. How anybody would have a problem with that is beyond me. Um, oh, there we go. Those who would give up essentially liberty to purchase a little temporary safety deserve neither liberty nor safety. Ben Franklin. I love it. Hell yeah. Hell yeah. Um, what's up, DB bastard? Old dirty bastard. The particularity requirement is fulfilled when the warrant identifies the items to be seized by their relation to designated crimes and when the description leaves nothing to the discretion of the officers executing the warrant. Amen, bitch. God, I'm going to love every second of watching this case and what we are about to learn. Okay. To see Diane Menashe and Jose Baez back in the courtroom again, and in a case where our rights were heavily violated, in my opinion. And I want to see how they handle this, and I want to see how the judge handles it. A warrant that fails this standard, one, that fails to adequately specify the material to be seized, thereby leaving the scope of the seizure to the discretion of the executing officer, it is constitutionally overbroad by that process. All three warrants here fall far short of this standard. Amen. They do. All of them. The iPhone warrant is an unconstitutional general warrant. The iPhone warrant authorizes law enforcement to seize and search 20 sweeping categories of data from Ms. Gardner's iPhone with no date restriction and no subject matter limitation beyond the generic assertion that evidence of a crime may be found there. Oh, shit. It's so true, though. It's so true. It authorizes seizure of it says any data related to user logins and passwords and any communication accessed, written, sent, or received or deleted without restriction as to time, recipient, subject matter, or connection to the charged offense. This is not a particularized warrant. It is a license to ransack. Shanna Gardner was not arrested yet. It is. The 11th Circuit confronted materially identical warrants, United States versus Blake, finding that warrants requiring a social media provider to disclose virtually every type of data that could be located in an account, including every message, every IP address, every photograph, every group membership, and every search, were overbroad and likely violated the Fourth Amendment's particularity requirements. And this is from the United States versus Blake. The court observed that the warrants could, let's see. The court observed that the warrants could have been tailored to, for example, messages sent to or from identified suspects during the relevant period. Oh my God, I just said that. Thank you so much, Lana. There you go, right there. But guess what? If we did that, we know that it's not going to be there. You know what I'm saying? They knew that it wasn't going to be there. That's what coming up with the circumstantial shit is all about. They knew that wasn't going to be there. So we need to get all this up because we're going to have to create this circumstantial case. And that's what's been my problem with the Shanna Gardner thing from jump is how are you including her? How? I mean, Henry Tenen came out back in the day when, he tried to make him the shooter. He never fucking talked to that broad. Ridiculous. The iPhone warrant here is more sweeping still. It covers not a social media account, but the entire contents of a physical device with no limitation, none whatsoever, despite the affiant's own knowledge of the specific suspects. Oh my God. Thank you. Despite at this point in time, you have, Henry Tenen, Mario, and you know that John Biggerstaff and that Jeremy Fuck, okay? You know all of that. So you can be specific because you're saying that that's the people who orchestrated this and who was all conspiring to kill Jared Bridegan. So why aren't you laying that the fuck out in your application for this warrant? Right? It should just like, everybody should be like, yeah, why wouldn't you? Despite the affiants, that is Detective Johns, that is, Detective Lamont, their knowledge at that point in time when they went and got this, they already had arrested Henry Tenen. Despite the affiant's own knowledge of the specific suspects, the specific date of the murder, and a defined preparatory period beginning as early as January 5th of 2022, there is no explanation and no conceivable justification for the complete absence of any restriction. This shit's going to get tossed, as it should. The iCloud and Google warrants are unconstitutionally overbroad in both time and subject matter. Please hit that thumbs up so this pushes out for more people to hear. Thank you. The iCloud and Google warrants are defective on two compounding grounds. Their temporal scope is unjustified and their subject matter scope is unlimited. Either defect alone would require suppression, either one. Together, they render these warrants indistinguishable from the general warrants for the Fourth Amendment was written to prohibit. Like, they're saying that either one of these is reasons to toss this shit. Together, they render these warrants indistinguishable from the general warrants that the Fourth Amendment was written to prohibit. Like, and everybody should be scratching their heads to say, like, did y'all really think that you were going to get away with this when y'all were writing this up? And you have the prosecutor who Johns is working with, same just like Ashley Jennings and Bill Thompson were. Did y'all think that this was just gonna fly? On a temporal scope, both warrants cover the period of November 1st, 2021 through March 27th, 2023, a span of nearly 17 months. Both warrants acknowledge this exceeds a typical request and justify it solely on the ground that this is a contract murder for hire, and the detailed planning, execution, and cover-up. But neither Detective Johns nor the issuing courts identified probable cause for murder for hire. Wow. Like, wow. That is not, you're kidding me, right? This is just mind-blowing. The probable cause findings were limited to premeditated murder and child abuse. How do you fucking say that? But then like, why? Oh my God. A temporal scope justified by an uncharged theory of a criminal liability for which no probable cause was found cannot be sustained. As the court held in State versus Timmons, search warrants should be limited to the time period that the affidavit suggests that the criminal activity occurred. And the failure to limit broad descriptive terms of relevant times when such times are available to the police will render a warrant over broad. Like, they had all this knowledge because they had access to Biggerstaff because he was the one that was talking to the cops that they hid and is like a confidential informant, whatever the fuck y'all want to say. He was the dude that was pumping the police and saying, "Here, listen, I'll testify against them, more or less, okay?" And it's just like, so then why aren't you using the information that he's providing and the time period of everything that he's saying? And it's because they were originally did you guys think this was going to be hidden from? I get like, that you're trying to keep this a secret, but the bigger question for me is, why are you cutting deals with killers? Because Henry Tennant's not the shooter. So who's the shooter? It's not Henry Tennant. And the state knows it's not Henry Tennant. But they were fine with him saying that it was him and doing what they did to him, because that's how the state was able to arrest Shanna Gardner and Mario Saldana off of all these lies. Just mind blowing. It's flat out sickening. The time period here is not tethered to any finding of probable cause as to Miss Gardner. It is arbitrary and it must be suppressed. On subject matter scope, the Google warrants 24 disclosure paragraphs and the iCloud warrants 9 disclosure paragraphs demand without subject matter limitation every category of data these providers maintain: emails, messages, photos, videos, drive contents, voice recordings, browsing history, search history, click history, geolocation data, app records, deleted data, and account metadata. This is a categorical dragnet indistinguishable from the warrants commended in Demons, where the court suppressed evidence obtained under warrants authorizing the wholesale seizure of account data before a separate provision nominally eliminating what law enforcement could retain, holding that the provider's asserted inability to distinguish evidence from innocent records does not justify the virtually unlimited scope of either step, and the detective could have and should have limited his search to those specific categories that were supported by probable cause in the affidavit. The Demons Court further held that warrant provisions authorizing seizure of all device identifiers, all account registration records, all location data, and all service records were patently overbroad, warning that if such justifications were permitted to stand, there would be no limits on what cell phone data law enforcement could seize or search in any given fucking case. Exactly. Amen. I'm telling you what's going to happen here, and it's going to happen real soon because I'm about to do it myself. Why would anybody want to use a smartphone anymore? I would start recommending, and this is what's going to start happening. Criminals are going to start having and use regularly 2 and 3 phones. So there is no pattern of anything. Just letting y'all know. The iCloud and Google warrants temporal limitations does not rescue them. The Demons Court made this point explicitly. A time restriction, while necessary, is not sufficient. The warrant must also be limited in subject matter to the categories of data for which probable cause has actually been established. They're trying to make a case when there isn't a case. No different than the Kohlberger case. The difference is in how the person that's writing this is going about it versus what they did in the Brian Kohlberger case. And that's where Ann Taylor failed because she's not a good litigator. It's just the truth. Nobody's a good litigator in Idaho because they don't litigate. Everything's a plea deal in Idaho. So you don't have any litigation. There's no litigating happening. The justification offered in both affidavits for the unlimited categorical sweep that the extended scope is necessary because this is a contract murder for hire. I cannot believe they wrote that. And detailed planning, execution, and cover-up does not rescue these warrants from their constitutionally, they're just defunct. They're just defunct. That assertion is offered to justify not merely the extended temporal scope, but the wholesale, unrestricted seizure of every category of data in both accounts without any attempt to identify which specific categories of data bear a nexus to the charged offense. It is, in substance, the same argument rejected by the Florida court in search warrant March 14, 15, 2023, that the nature of the crime justifies producing the entirety of an account to law enforcement, which will then decide for itself what is relevant. Yeah, that's not going to fly. That court flatly condemned this two-step procedure as one that divests the judiciary of discretion, rendering us completely inert while the police examine, search, and decide what use to make of the entirety of a suspect's social media account. Who do these people think that they are? And characterize it as nothing less than a reprise of those general warrants visited upon our qualifier boards that support the enhancement of the Fourth Amendment. Yeah, it's just how you're even how the prosecutors and the law enforcement people are even attempting to justify this shit when they're writing this shit should scare the shit out of everybody. Because when they're writing it, they know what the fuck they're doing. That's why I have an issue with Cyray's assertions about the fact that the system needs fixed. And so these policies are in place that holds everybody's feet to the fire. At the end of the day, it's still humans. Humans made the decisions that they did in the Brian Kohlberger case. And I believe that they knowingly were reckless and did it on purpose. This wasn't some, I have no ill will here. The fuck out of here. You can tell yourself that all you want because I get it. He needs to work in the field still, but that's just not the truth. And so, whatever. Indeed, the complexity of a crime does not suspend. I love this. I love it. Just because the crime is complex, it does not suspend the particularity requirement. God, this is so well written, man. This is sick. This is so good. Rather, it heightens the obligation to identify with precision what evidence is sought and why. Exactly. And I know that this is what Cy is trying to go about the route of, like, you want to preserve all this data, you know? Neither the affidavit makes that showing, and the contract murder rationale standing alone cannot substitute for it. Moreover, as the Demons Court recognized, a more generalized seizure may be justified where the government establishes probable cause to believe that the entire account is merely a scheme to defraud, or that all of the account's records are likely to evidence criminal activity. No such showing was made in this case, though. The affidavits do not allege and could not credibly allege that every email, every photograph, every search query, every location record, and every deleted file in Miss Gardner's iCloud and Google accounts from November 2021 through March of 2023 constitutes evidence of murder. The contract murder rationale is a conclusion masquerading as a justification. It is not enough. Love it. Fuck your conclusionary shit, okay? That's what they did here. That's bullshit. And now they want to Franks. Oh my God. What's up, Heather? How you doing? What's up, Kim? I'm loving this writing right here. Everybody needs to frame this, put it on their wall. Now let's see what they're asking for. They're asking for a Franks hearing, and Franks is required. So let's see. A warrant is not a general hunting license. This is great. This is fucking fabulous shit right here. Nor is it a mantle which cloaks its holders in the king's power to do no wrong. And perhaps most importantly, it is not an excuse if the police are not frank with the magistrate in proceeding to obtain the warrant, proceedings that are typically ex parte. Oh, yes. Right here. Yep. We all know this. Under Franks v. Delaware, a defendant is entitled to a hearing upon making a substantial preliminary showing that the affiant here knowingly and intentionally or with reckless disregard for the truth included a false statement in the warrant affidavit. And he did. I love it. Fuck yeah. Hold his nuts and crush them. Yep. And that the false statement, the key thing here is and. So he did this stuff, and that the false statement was necessary to the finding of probable cause. And this is what Ann Taylor struggled to do. Okay. Ann Taylor needs to literally call in sick. And when this Franks hearing is held, and it's in the open viewing for all of us to watch here in this case, Ann Taylor better get her fucking ass on the goddamn couch, grab some fucking popcorn, and press play, motherfucker. All the people in Idaho should. The false statement was necessary. Just like the probable cause statements that Payne made, they were necessary. Dylan's bullshit was needed to create the timeline of the fucking crime. And without Dylan's ridiculous statement that they knew was not true, okay, they needed that for the time of the crime. Because if your client's phone is being shut off, who the fuck cares if everybody was killed and starting to be killed at 2:53, Anne? Right? Right, Lana. Right. So why you wouldn't go that route is fucking beyond me to defend Brian Koberger. Beyond me. And that's what Chris Holland was trying to get Ann Taylor to recognize. Was that this crime scene was multiple perpetrators, or if it was one person, that person was in there for a hell of a long time. Not 4 fucking minutes, not 6 minutes. Okay. AT was terrible at oral arguments. She just fell apart under pressure. Yeah, and I feel like but if her shit would have been written like this, so that she could just go through her her written work to then orally argue each point. Come on, have you not given a public speaking class in your life in college? Hello, Lana. Thank you for your time and sharing with others. Sure thing, Kim. Happy Cinco de Mayo. Happy Cinco de Mayo, everybody. Where is WSU Kim? Mom, should I give her a call and ask her what the hell she's doing on this lovely Cinco de Fucko? So, the same standard applies to material omissions, where an affiant omits information that is clearly critical. So the fog lights, Anne, you couldn't tell that fucking vehicle had fog lights on it, and Brian Kohlberger's doesn't. There's just so many things you couldn't tell that the feds lied. Well, she didn't. She would have once she got the report. The feds lied about the white car at crossing at 331, or I'm sorry, at 329 at 1311 South Main Street there. I mean, there's just, don't even get me started. It makes you want to puke. It's just, you just wonder what type of fucking homework they did. And I get it. Trust me, Judge Hippler was going to probably rule against her, but you would have had such a sound, whatever. Moving on over here. I just cannot even get into it. Sorry, excuse me. I have no idea. Hold on. Okay, take a look here. Right here. The same standard applies to material omissions, where an affiant omits information that is clearly critical to the probable cause determination. Recklessness may be inferred, and a Frank's hearing is required. Affiants are obligated to include information of the kind, quote unquote, the judge would wish to know in evaluating probable cause. All three affidavits here omit a fact that each issuing judge would unquestionably have wished to know, and that is that Apple and Google possess the technical capability to conduct targeted, particularized searches of account data by date, keyword, file type, or other limiting criteria, rendering it entirely unnecessary to produce the entirety of an account or extract the full contents of a phone. This omission is not inadvertent. Law enforcement is aware of these capabilities. You know, that training and experience. Had the issuing judges been informed that selective production was readily available, they would have had before them the very information that led the courts and demons and then that search warrant. See how they went about this, Anne? This is genius. And it rejected the identical warrant application. This is precisely the kind of material omission that Frank's is designed to address. A hearing is required. Oh my God, Lana, I found Pullman police meetings on YouTube, and I know what Gare Bear was on a month before the crimes. Yeah, let me know. She pointed out that Thompson had a Brady on him. Well, we already knew that. That's been out there for a long time. But we're questioning if that's even accurate. Because some of those sites, guys, you just can't go off of them. So you have to really be careful. Conclusion. The iPhone, the iCloud, and the Google warrants are constitutionally defective. The supporting affidavits fail to establish probable cause as to Miss Gardner personally and fail to establish a nexus between the charged offenses and the specific accounts and device to be searched. Even had probable cause been established, the warrants are not particularized as the Fourth Amendment and Article 1, Section 12 of the Florida Constitution require. Dude, they just made Judge Kite's decision here, I think, so easy because of the way that they went about this and how she can make her decision and it be upheld by previous laws, previous case precedent, rather. They are categorically dragged. That's unlimited in subject matter in the case of the iPhone warrant, unlimited in time that gave law enforcement unfettered access to the entirety of Ms. Gardner's digital life. They are general warrants. The Constitution forbids them. Florida courts have condemned them. And this court should suppress all evidence obtained pursuant to them. Oh my God. What do you guys think? Oh, shit. Wherefore, Shanna Gardner specifically requests that the court enter an order suppressing all evidence obtained pursuant to the iPhone warrant, the iCloud warrant, and the Google warrant, scheduling a Frank's hearing, and granting such further relief as this course. I just want to see this, like, put it on the books. Here it comes. Let's get a good Frank's, okay? A good preliminary showing, right? This was just filed a couple weeks ago by Shanna Gardner's defense team, which is led by Diane Menashe and Jose Baez, and that is going to trial. We will be gavel to gavel with this case. It's very interesting. Now let's take a look and see. I've given 2 weeks here. I want to see who would cover this. Okay. So if we type in Shanna Gardner on YouTube, and we'll put Jared Brightigan too. And if you go, there is nothing that you can find where anybody is talking about this case. But we're talking about it right now, so we're live talking about it. The last thing is 3 weeks ago, the trial date set in twisted Microsoft executive murder case. And let me tell you why they're saying it's twisted. Because they severed the cases now. I cannot believe how this is going to work. Okay, everybody is being charged differently, or like separately. They're having a separate trial for Mario. They're having a separate trial for Gardner. Okay, and they're having a separate trial for Henry Tenen. But John Biggerstaff has not been charged with anything. Okay. And this is the trial order establishing the schedule and pretrial procedures for these severed trials now. Let me show you this. So Mario Saldana is going first. Yes, I agree. Yes, 1000%. So take a look. The jury selection for Mario Saldana it begins the week of August 10th. The jury pool. So this is what they're going to do. They're going to have their jury pool, and it's going to be 250 people, okay? The voir dire will be conducted in 2 phases. Let's take a look. And I'm like, wait, what? Phase 1 is the prospective jurors will be qualified and will be examined for hardship, pretrial publicity, and grounds for cause challenge pursuant to. That's normal. The jurors that are not excused by the court will be required to read and sign the communication instructions by the court, which will be the cover page with the questionnaire. Next, the prospective juror must complete a questionnaire. The prospective juror will be required to report to phase 2 of jury selection. Counsel for the state and defendants shall have a representative review the juror questionnaires before the juries are excused for phase 2 of jury selection. Phase 2. The prospective jurors may be questioned regarding substantive matters by the attorney. During voir dire, counsel shall strictly adhere to referring to the prospective jurors by juror number only. So they're going to do individual jury, like they can ask them whatever they want. I'm like, this is going to take forever. Trial schedule. Mario Saldana's trial shall commence on August 17th and is scheduled to continue through August 28th. Okay. Then the trial of Shanna Lee Gardner, defendant B. Jury selection the week of August 31st, 2026 through September 4th, 2026. The court may require extended hours and weekend availability of the parties to ensure that a jury is seated in the trial of Shanna Gardner. Jury pool, considering the substantial pretrial publicity in this matter, the court has summoned and ordered 500 prospective jurors. Okay. And this is a completely different field. Do you know that the state wanted the jury pool to be the same people? That like whoever wasn't picked, okay, for the first one, they would be like still there to be picked for the second one. I said, what the fuck? I said, that's gotta be the dumbest shit I've ever heard in my life. Okay. What? Fucking A. And they wanted to pick him at the same time. And then they wanted to swear them in at the same time. And then just have Shanna Gardner's jury sit there waiting somewhere like in La La Land. Don't look at the fucking internet. Don't watch fucking Mario's case, okay? And, and we tell you to report here. It's just like, what the fuck are y'all talking about? Then Jose Baez and the defense is like, okay, let me talk to you guys about what's going to happen here. This is how we're doing things. So again, so check this out. The court will conduct it. Okay, blah, 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 blah. The jurors that are not excused by the court will be required to read and sign. Same thing, okay? So then they'll go on. Phase 2, the prospective jurors will be given maybe questioned regarding, okay, great, awesome. And then her trial, this is what we're going to be covering. I mean, we're covering both of them, okay? Hers is September 8th through September 25th, okay? And his is, again, it's the last week of August, basically. So that's what we're going to be doing over here. Now, the jury selection and related matters, they said, hey, this is how this is going to work. The court finds, so like turn in whatever questions that you want, blah, blah, meet and confer requirements. Counsel for each party must review the court's jury questionnaire. The court's proposed questionnaire was developed pursuant and all that type of shit. They're doing it 30 days before the trial. Everything has to be, okayed. And then we get into the jury selection partial closure notification to the media. So check this out. The court intends to conduct only a portion of jury selection outside the courtroom. It is important to note that the media will not be excluded from courtroom for jury selection. The court anticipates the following events during phase 1 of jury selection: opening the proceedings, introduction of the parties, informing the prospective jurors of the trial schedule, reading the statement of facts. The jurors are then separated. At the conclusion of the main proceedings, as discussed above, the prospective jurors will be organized into 2 groups. Group 1, the first group, will remain in the courtroom and complete the questionnaire if they do not want to be heard regarding an issue related to hardship, blah, blah, all that crap, right? And I'm like, what do you mean separated? Well, the second group will be organized for individual voir dire by the court, and the parties will start questioning them. Okay? And they're going to do this in a room adjacent to the courtroom, outside the presence of other prospective jurors, spectators, and presumably the media. And I'm like, wait a second, what? This is a private voir dire? I've never heard of anything like this in my life. Okay. Maybe y'all have heard, but I don't know. So, as previously stated, the inquiry will only be regarding hardship, pretrial publicity, and grounds for cause of challenge pursuant to that. Awesome. Additionally, only this portion of the jury selection with group 2 will be conducted in this manner. And I'm just like, wait, so we don't get to hear any of the questions that you're asking these people? Now, pursuant to the Miami Herald publication, blah, 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 the court gives notice to the media that the above reference procedure will be utilized to select a jury in trials of Mario and Shanna Gardner. If there is an objection to the proposed phase 1 jury selection procedure on behalf of the media outlet, the written motions must be filed on or before May 8th. Like right this week, okay? And a courtesy copy sent to the court is required to notify at least one representative of the local media when a motion for closure is filed and when it is heard by the court. So they're like, listen, we're going to close this out. And I'm over here like, why? Statement of facts for pretrial publicity voir dire. The court recognizes that this matter has been the subject of intensive. I just don't think it has. Nowhere near what it should be. Okay. Whatever. The state and the counsel for each defendant shall meet, confer, and jointly prepare a neutral, factual, and non-argumentative statement of facts to be read. Wait, what? The court to the this is what you're going to read at the beginning. What is Judge Kite doing? The statement of facts shall be confined to objectively verifiable matters of public record and shall not contain argument, characterization, or evidentiary matter. Lana, there has been not letting me watch you for some reason. They switched me on change phone and a massive fan. I'm sorry about that, George. I think you should just take a curling iron and stick it up someone's ass. I'm just kidding, George. That's actually a case that happened over here in Columbus. Somebody took a hot curling iron, and I guess we're dealing. I don't know. The things people do after a couple beverages. I'm sorry, George, but I'm glad that you're here right now. So yeah. A separate statement of facts shall be prepared for the trial of each defendant, taking into account any change in media coverage that may impact the prospective juror. What? This is crazy. This is absolutely wild. All right. Okay, courtroom technology, electronic exhibits, and evidence. This is how this case is going to be handled. So, given the volume of evidence anticipated to be presented at trial and parties' expected reliance on electronic exhibits, the court orders the following with respect to courtroom technology. We'll just get a fucking Hector. Okay, I don't understand. Hector's great. These things that I'm using, I just don't get it. Mandatory equipment training. This is fucking amazing. Oh my God. Mandatory equipment training, you guys. We are going to have mandatory equipment training because we are not Detective Johns. Okay. Have you ever seen such a thing in your life? Mandatory counsel training. Counsel for the state and counsel for each defendant who anticipate presenting evidence at trial shall meet with the court's information technology department to receive training on the courtroom's presentation equipment, evidence display system, audio visual systems, and any other technology to be used at trial. Because this is not, we're not going to be delayed because you don't know how to use a fucking overhead projector. Okay. You understand that? So you're going to get your asses in here and you're going to get some fucking training on how to use this equipment. This is hilarious. Okay. Next thing. Okay. And guess what? If you guys do not pass the class, you're not going to fucking use my equipment. You guys aren't breaking my shit, man. Compatibility of electronic exhibits. The party shall ensure, in coordination with the court's information technology department, that all the electronic exhibits intended to be offered at trial are fully compatible with the courtroom equipment. God damn it. Okay, like this is not negotiable here. This is like a dating requirement. Like a dating requirement. Damn, shit, fuck, whore. This is hilarious. There's going to be no issues in Judge Kite's court, okay? Her courtroom is like, you're going to come in here for some damn training. If you don't know how to work a fucking computer and a laptop, we're going to talk about this shit, okay? Now, compatibility testing shall include, without limitation, the verification of file formats, playback of audio and video files, the display of digital images, and the operation of any specialized presentation software. Do you hear me? We're not playing around here. Carson's mom, do you hear me? We're running a tight ship. Now, you're going to coordinate with the fucking clerk of court. Do you hear me? Prior to submission of any electronic exhibit, counsel shall confirm with the clerk of court. You're going to talk to that woman who's breathing into that device, and you're going to explain how this is going to work. And she's going to explain to you if that's okay. Because we're going to have these electronic exhibits must be capable of being opened, accessed, and maintained by the clerk in the format submitted. God damn it. We're not fucking around. You better have an IT guy here. Okay, we're not playing. We're going to have training. I am going to call up Diane Menashe, I think tomorrow on the phone, and I'm going to say, hey, Diane, I was wondering if you and your team have sat down and looked over your requirements, and if you guys have taken your training, your mandatory equipment training course yet. Do you have any comment on that? Thanks. Have a nice day, Diane. I'm going to go ahead and give Jose a call now. Let's see how he's feeling about this. Okay. So listen here, ladies and gentlemen. I'm being serious. If you don't, no electronic exhibit shall be tendered to the clerk without such prior confirmation. We're not accepting it. This is life and death. I don't care. Okay. If you don't give me this piece of paper the way that it needs to be, then it ain't coming in. All right, Judge Kite, we got you. And the way that you're exchanging these exhibits, the parties shall exchange and pre-mark all proposed exhibits for identification. We're not playing. Okay? We're not playing here. You're going to pre-mark these exhibits. Y'all are going to exchange with each other. Play footsie over there. Do whatever. And shall provide the court with the exhibit list no later than 5 days prior to the commencement of jury selection. Do you hear me? This is non-negotiable. If this does not happen, these are not coming in. Not in my courtroom. Okay. Well, the defendant's exhibit exchange exception is this. The court will not require the exchange of exhibits by the defense if strategic reasons exist that may prejudice the defendants. However, prior to the counsel seeking the admission of the exhibit, counsel must comply with rule. Listen, I know that you want to impeach the shit out of that person, and I get that you don't want to go giving your exhibits ahead of time, because then we're going to have some Karen Reed type shit where people are, hey, I'm going to bring you in and I'm going to tell you what's coming your way. I get that. So if those are impeachment material, that's okay. We'll let those come in. Just follow the rules. Rule 3.220D. Okay? Now, these demonstrative aids, I'm going to tell you guys, they better be big enough and they better be in color. Okay? No black and white. Okay, Judge Kite, what else? Well, this demonstrative aids here, to the extent that there may be the use of exhibits not entered into evidence, but you just want to make like houses, like little houses, and have them be like, here's my 3D model. Well, how we're going to work this is that all demonstrative aids shall be disclosed to opposing counsel in advance of their use in trial and marked as a court exhibit for the record. Do you understand that? Mm-hmm. Oh, shit. What else you got? Well, while I'm on this fucking soapbox of mine, Judge Kite says, she's like, clerk notification requirement. This is how this is going to run. The parties must notify the clerk of court of the estimated number of exhibit stickers that will be needed to prepare for the admission of exhibits. Excuse me? Yeah. Okay. Let me explain to you how this is going to work. I need to go to Amazon and purchase these stickers, and I need to know how many I need to buy. That's, we're not playing around here. So I want to know how many fucking stickers I'm going to need. Because I'm not going to have this clerk running all around with her breathing machine. So these exhibit stickers, you better be prepared to let me know exactly how many I need to bring in. Unbelievable that you think that I'm going to buy extra exhibit stickers. What? We put our own stickers on them, Judge Kite. Like, what are you talking about? Well, no, not here. You hear me? I need to know the estimated number of exhibit stickers that will be needed to be prepared for the admission of evidence and court exhibits. This notification must be made at least 48 hours in advance of the admission of the exhibits and may occur without notification of opposing counsel, as it is only for preparation and logistic purposes. Okay, Amazon is only going to guarantee me my stickers within 24 hours, so you have to get me this information within 48. Oh, okay. Those things are like, you can buy those for like $500 for maybe, I don't know, like $6. Whatever. Now, defendant interviews or statements. If counsel intends to introduce a video or audio recording of a defendant, the proponent of the evidence must meet and confer with opposing counsel. The final version of the recorded statement must be verified and watched by opposing counsel. If there is an objection to the evidence, there must be a written motion filed at least 30 days prior to the jury selection. Well, damn, this is Jose. This is important for you. They're going to try to introduce, I think, some of those statements. Make sure you guys are on that. The depositions or prior statements transcribed. If counsel intends to use transcripts to impeach a witness, yep, that's happening. A ton of it. Then an electronic copy of the transcript must be provided to the court on or before the first day of trial. The court's electronic copy will be filed as a court exhibit at the conclusion of the trial. You're going to be handing these people, they are going to see their words, not on some Hector. You're going to print that shit out and you're going to hand it to them. It's going to be an exhibit, goddammit. Are we clear? When these jurors are going to go back to that room and deliberate, our shit is going to be nice and organized. They ain't going to be shit all over the place. Are we feeling each other here? Mm-hmm. Okay. Now, pretrial deadlines and hearings. Listen up. Motions in limine. Do you even know what that is, guys? Jose's like, what the fuck? This is like first day of fucking law class or some shit. This is crazy. Motions in limine. All motions in limine shall be filed and noticed for hearing no later than 5 days prior to the commencement of jury selection. Exactly. So I have a question. This is how normally it goes. So why was Judge Hippler doing all of this stuff like, whoa, like 6, 7, 8 months before trial? Crazy. Final pretrial conference. We're going to talk about it. Okay, we're going to go over all of this. A final pretrial conference will be held in each case. At the final pretrial conference, the parties shall be prepared to address all outstanding issues, motions, witness lists, exhibit lists, jury instructions, trial logistics, and inquiry into negotiations that the parties deem appropriate for the record. Okay? Now we're going to start talking about food. Are you allowed to have food in the courtroom? Let's talk about it. Who knows? Proposed jury instructions and verdict forms. Oh, verdict forms. Well, proposed jury instructions and the verdict forms will be prepared by the court based upon the indictment. Duh. If there is a special request for jury instructions, counsel must notify me, okay? Otherwise, we fly in. Judge Kite, I love you. Discovery and witness list. Okay, I'm leaving no stone unturned here. Okay. Now, counsel are directed to confirm at least 60 days prior to the final pretrial that Rule 3.220 Florida Rules of Criminal Procedure have been fully complied with and that all disclosures are complete. I want that certificate. Okay. Now, media coverage. Media coverage. Listen up. You're going gavel to gavel? Well, this is what media coverage of the proceedings shall be governed by Rule 2.450 General Practice and Judicial Administration Rules. Blah, blah, blah. Requests for expanded media coverage shall be directed to the media committee or this court in advance of the proceedings. Well, I want to know if I can be the camera pool. Since nobody seems to care about this case, can I just run my YouTube as the camera pool? How about that? Now, this is our courtroom seating. The jury selection and trial proceedings will be held in courtroom 407, the ceremonial courtroom. You understand me? Spectator seating may be limited to accommodating the parties, counsel, witnesses, jurors, next of kin, defendants, family, and the press. So the rest of you guys are fucked. You hear? Now, counsel for the parties must determine the number of requested seats for jury selection and the trial and provide the number of requested seats to these people. You better talk to Eve. I'm going to give you a call, Eve. We're going to go out for some drinks. I'm going to be on that list, okay? This all better happen right after the 4th. So get tanked, light some fireworks off, and then you better come in here knowing what the fuck's up. You hear? Okay. Now, additional requests. Any additional accommodations requests shall be provided to the court administration on or before July 6th, and this would go for anybody with ADD. If you have ADD and you want little buckets of Adderall to be placed around the courtroom, just in case you need to pick it up and put it in your mouth while we're proceeding during the middle of the day to keep you on track, we can accommodate that. Now, anybody need Adderall? The defendants are not allowed to have any Adderall. Now, electronic devices. This is how we're going to roll with electronic devices, okay? Is the use of cellular telephones, recording devices, cameras, and other electronic devices in this courtroom, that's just a no-no, guys. It's just not happening. Now, the reservation of jurisdiction. All prior orders of this court, including but not limited to discovery orders, the priority case order, all of the shit that I've done in this case, guys, I'm right here. It's me, Judge Kite. I'm here. Okay. Now, I think that is going to conclude the trial order establishing schedule and pretrial procedures for the severed trials. Are there any questions? Oh, thank God. Thank God. I have a question. Are we allowed to videotape in order for us to remember how to use your equipment? Or is that fine if we videotape the mandatory equipment training? Are we able to videotape that? I have a problem with remembering sometimes. So am I able to videotape my interactions with the court's information technology department specialist? Thanks. Okay, perfect. No questions here then. All set. Huh. Well. You guys. Leanna, are we going to party in Florida? That's where my parents live. Yeah. I'm going to be in Jacksonville. Let's go. Wow. All right. What happened in the world today, Idaho4? Well, people are just losing their minds. That's what's happening. We had fun with your stickers, hon. I cannot believe that she wants to know how many stickers I need. Judge Kite, I'm telling you though, I really like her. And she's just really organized and she's just being efficient, you know? And I think she just wants everything to flow really smoothly. This is going to be live on television. I just don't think she wants any blunders, you know, just a blunder. Well, okay. No blundies. So I'm just hoping that she really focuses on this defendant's motion to suppress evidence obtained pursuant to unlawful search warrants and for Frank's hearing. I haven't even gotten to see what Mario's filed because I saw this and I was like, oh, it's on. Detective Johns, you are so fucked. I love her. I love her. And I love how she talks to them, the attorneys, like, she's like, what have y'all done? Like, what have y'all been doing? Like, not like, Mr. Baez, have y'all talked? Where do y'all stand on this? Were y'all gonna let me in on the fact that you want to sever these trials? y'all. I feel like she would be a best wedding planner. Yeah, fuck, shoot myself with that. But yeah, maybe she likes to. We are not going to have any shenanigans in this courtroom. We have to do training. You guys, so funny. How could you not laugh at that? I'm totally going to call Diane Menashe and ask her, Miss Menashe, have you set up your mandatory equipment training? This is Eve over at the Florida courthouse. I noticed that your name is not on our list. You have a mandatory equipment training set up with us? Miss Diane Menashe, this is Lana with Truth and Transparency, and we just punked you. Have a great day. Can we record it? Fuck yeah, we can. Let's play a trick on her. This is Tina with the mandatory equipment training over there at the Duval County Courthouse. We're wondering, Diane Menashe, if you've signed up for your mandatory equipment training. We don't see your name here, ma'am. And it looks like you're not going to be able to be part of the trial. So she made a clear and honest. This is a syllabus. This is a college syllabus. Oh, fuck. All right. Let me show you in case you guys don't know Judge Kite.
Two or 3 weeks. That does concern me, and I'd like to.
August 10th. His trial would be August 17th through the week of the 24th.
Yes, Your Honor. Yes, Your Honor.
Okay. Did you all discuss sealing or non-sealing?
This is hilarious.
No, we did not, but I assume it would proceed as a normal trial.
Okay. I'll discuss that matter later, but so as to not impact the second jury, my suggestion would be to seal and then publish at the same time. And then just summon the other jury when the other case concludes.
The dumbest I've ever heard.
They wouldn't be sequestered. They'd already reached a verdict. Then I would seal the verdict until the other case concludes.
Different defendants in 3 different motions. So I would like time to make sure I'm prepared for all 3 defendants' motions with whatever necessary witnesses I need.
God, here. So this right here is Stifler. Her last name Stifler. She's one of the prosecutors. This is Marahi. It's Maserati to me. And over here is where's
This is found not guilty.
Where's Jose? He comes up on the screen. He's like
into the holiday weekend. Okay, and then we would start the trial September 8th. And what's the thought between the parties of how long Ms. Gardner would take? A week, 2 weeks?
I think 2 weeks. Yes, Your Honor. Until the 18th, if you want to block that off. I have a better sense from the Fernandez team about how long the trial will take than I do from the Gardner team. I will talk to them if we need additional time. If they think they're going to need additional time for their case, they can let me know and we can let the court know.
Let's see what's going on here. Just a little twist of events here. Like all of this shit. Shocking text exposed. Get the fuck out of here. Shocking text from like judge frustrated. There's Jose.
It's probably a 2-hour hearing, I guess.
I had time to review the motion. It's pretty straightforward from the state's point of view. I don't know necessarily if I'll need a witness or just introduction of evidence, but I would probably say 3 hours just to be safe.
Good call.
And we have motion hearing time set aside the week of May 4th, the week of May 11th. I set one for Mr. Tenon the week of May 11th, which is also quite short. I'm anticipating getting suppression motion from Ms. Gardner's team, as Mr. Carodi said, on the T3 wire. So that one might be a little lengthier.
Oh, you
and
know
I'll
what?
defer to Mr.
Let me see if the state has commented on Mario Saldana's he did a suppression. Let me see if they responded. Hold on. Oh, fuck off. God damn it. Always something with my logins. Saldana. Does it go with Fernandez? Let's see. Okay, perfect. Oh, that's negligence. That's not the one I want. Okay, here we go. There we go. Let's see if they responded all the way down here. He's got some really good attorneys. Oh, wow. They did just file. Motion to adopt defendant Gardner's motion to exclude testimony of minor child. Holy shit. Has the state not responded? What the fuck? What the hell is the state doing? When was that filed? Let's see what they. So in Mario's case, so it comes now the defendant Mario Fernandez Saldana by and through his undersigned counsel. On March 16th, 2023, defendant was arrested for one count of murder. Okay. On April 15th, counsel co-defendant Shanna Gardner filed a motion to exclude testimony of minor child in this case. Given the same, minor is expected to testify at trial against the defendant. Defendant moves to adopt the motion to exclude testimony of a minor child that was filed by Ms. Gardner's counsel on April 15th, 2026. She doesn't want her kids brought in on this. Interesting. When did he file this? Here, I'll share this portal so you guys can see what I'm looking at. This is the portal that you go to for the Duval County courts. They're a joke, but you can get your hands on a lot of things. And look at all the things that have been filed in this case. Like so much shit. Anyways, I print all this shit. But I go back down here. They filed so many things. See this trial orders establishing schedule and pretrial procedures for separate trials. That's what I read to you guys. Who are they deposing now? Oh my god, again, I love it. Fucking Detective Johns. CL Johns. Oh, so great. Yeah. May 18th and 19th, they're deposing him again. He's been deposed unless he's been calling off on these, like, and not showing up, but he's been deposed a shit ton. This is how it should be for every case that's criminal. Is you should be able to depose people. Oh, did that go back down like that? Oh shit. Hold on. Look at so Mario when he did his right here. All these depositions. Motion to suppress defendant's cell phone records seized pursuant to T-Mobile search warrant. That was on March 30th. They have not responded. The state has not responded. Look at this. Like, where is it? Where is the state's response? Unless they sealed it. But they don't do that in this fucking shit. But what should be here is the state's response. But on 5/13, there's a hearing on motion to suppress. So at least we get that coming up here next week. On 5/13, I'll be live with that. And that's at I think it's at, what time is it? Uh 10 to 12 maybe. Court date previously set for May 13, 2026 for hearing on motion to suppress. So, Alley Tally, turning people green. This case, I'm telling you guys, this case is going to be off the chain. The shit that's going to come out in this case, swingers and I don't know how it's all going to be relevant. I don't know. I think there's going to be a lot of objecting. It's just going to be crazy. I'm here for it, though, because they lie their asses off. I don't think Shanna Gardner knew that whatever Mario Saldana could have been up to with these fucking idiots. I just don't. She wasn't. It just doesn't make any sense. What a stupid plan. Who plans and plots a murder for right after the kids have been dropped off? Like, just dumb. She was spot on the first whistleblower, though, and nobody can call me WSU Kim anymore. Oh, people were calling you that? Oh, here, let me go ahead and play. So she was on Birdies. Let me go check that out. I'll play some of it here. Birdie. Alley Tally. Rocking it. Always rocking it. Okay, so when did she come on panel? Let's see. Did she just call him? Okay.
Quadruple homicide and a stabbing. I feel like the level of power when you have every agency involved, that get the damn president putting something out on True Social about it's world news, that kind of goes out the window. So help me understand what you just said then about the Showalter family. They're not just anybody. Can you give some insight into that?
Yeah, they are. They're all, they both, I'm not sure if both parents, but the parents are, both of Showalter's parents are doctors in the medical field. His mother does really great work in Africa. She really does. So I have nothing to say negative about that. But privilege is one thing. Privilege is a zip code. Entitlement is this. is getting to sit in the interview with your son because you think you're an attorney. Get your son an attorney because it happens. It just so happens his uncle is, I want to say the attorney general or the prosecuting attorney.
Who?
And I know that because
What?
Jack Showalter, according to this guy's daughter, said he was at my house in Pullman or my apartment in Pullman.
Wait. Who? Jack
Okay.
Showalter? Wait, what?
So
I know.
What I'm picking up what you're putting down. You think Showalter is he's
I think he was
suspicious.
smoking a cigarette and he was there. He was lookout. I don't think they might have made him do something. I think they made him do something so he couldn't snitch.
So he couldn't snitch. So you
And his parents had cut him off because he had failed out of school. So why he has a degree, I have no clue. But he said in his interview he was on probation. He wasn't. As far as I was under the impression, he had failed out for the last time. He was done. He was out. He's a sophomore, right? And so
What?
he also was tossed
No,
from
he
his
wasn't.
fraternity. To get tossed out of Greek is
He's a senior. A sophomore? He wasn't a sophomore.
like wearing a scarlet letter. It's ridiculous and stupid and dumb, but it's also young adults thinking things matter. But he got dropped. I don't know if Kaylee dropped or she was dropped, or Xana got dropped or she was dropped. The three of them were dropped.
Who?
so I don't want to just brush over the fact that you just
I know we
said
just
that
went the other way.
Showalter-
I know. I just
No, that's totally fine. I'm just my mind's also
Wait.
going a million miles an hour. So you had just said you believe that Showalter was outside smoking a cigarette, and
I
that
did.
when you say they made him do something so he couldn't snitch, right? You said he was a lookout. Who do you believe they is?
I believe they are
Dimitri.
the bread baker and the special needs son. I do not remember his name, and I believe he's on the spectrum, so please don't. I'm not insulting anybody. I'm just saying,
Wait,
Yeah.
what?
redheaded man. I believe he's on a large guy. There's picture of Bubbly has his name. I know she does, and he was there. I believe he was there, and whoever the plumber was there. I believe Demetrius was there,
What?
and
Wait a second. This is Tina with What the Fuck Services. What the fuck is going on here?
Emma was there. Or actually, okay, so I don't believe Demetrius is there. I think he has a paycheck and a pay stub from V Hall saying he was DJing that night.
Wow. So plumber, a redheaded large fella, bread maker.
The bread maker. And the Mad Greek, I'm not so sure they're not involved. I'm not so sure they're not involved. What do I care?
I'm not stopping you from saying anything here. So if you want to,
I believe that the bread baker, Mad Greek, yes, I
The
believe
bread
that.
baker.
I believe the police know what everything that happened. I mean, how did that Santa Claus they call him? What's his name? How did he pick up Brady
Bill
during all of
Thompson.
this? Bill Thompson. He got a Brady during all of this. For what? What did he do?
What the hell is going on?
In the middle of this case, he pulls a Brady. That's
Oh, is
sus
he-
to me right out the
The
gate.
plumber left
I had heard
and his
from
clothes-
somebody that's a local that the Brady violation.
See that stuff.
Are you talking about in the police department? Because we had heard from somebody
No, Bill Thompson got one.
Okay, so it's not the police officer that didn't respond to a suicide call because he was hanging out with his girlfriend.
Yeah, he has one too. Yeah, that guy, yes, he has one. But which is, bad choice. But Thompson picked one up.
Okay.
I didn't know an attorney could.
So
If you
okay.
Google it, it'll pop up.
So I'm gonna, yeah. If you want to get,
Yeah, I don't know.
But Bill Thompson,
here we go.
people and parents, and so, So we're all fighting. I lost the question again. Fill me in.
Oh, I said you must think that if you'd said it's knowledge that's essentially eating away at people like Hunter.
Right.
I said you got to think that there'd be some level of protection that these people could get for telling the truth then.
Oh, right. Like going, yes, but you know how that looks, right? Because if they snitch, the people who are offering that to them might be involved. They don't necessarily know who they're snitching on.
What?
They've got, and when Maddie said, "I'm sick of it, I'm done," that triggered something. And I think she really was done with whatever she was speaking of on. She was done, and that triggered chaos.
I mean, geez. Kim, is there anybody that your daughter knows that would be willing to pop on the stream at any point and anonymously spill the beans?
No, trust me, oh my gosh, she was just home. She came home yesterday or last weekend, and I'm like, I feel like I have to die before I get to find out who did it. And she said, Mom. And I said, just tell me, I promise I won't tell anybody. That's a lie. She knows that. And she said, I don't know who did it, Mom. She said, but nobody's ever going to speak. And
Yeah.
if she knew who did it, she would say, I would make her say.
I believe you on that, right? Like the way that you talk about your daughter and the way that you talk about the situation. I do believe you that, and I also, even if that wasn't true, right? I'm not saying that
Right.
you're lying. I'm saying, but
Sure.
I could see why somebody would say, yeah, I mean, there's no way I'm not going to put somebody at risk. I get that.
Right. Yeah. I mean, I left my kid in jail for 3 days because I got in a fight with his sister at a party somewhere and made my daughter sit in the lobby. You're going to sit. I did not raise prisoners. I put 7 people on this planet. You best show up.
I feel you on that. And so I'm just going to do some rapid fire questions here. Okay.
And I'll be trying to stay in my lane.
No. And Kim, I just want to say too, like, I appreciate you coming up here being willing
Oh,
to do
no
this.
worries. Not a big deal.
Yes. Thank you so much. And
Oh,
okay. First rapid fire question. Do you know what the exculpatory evidence is that Bethany may have?
I do not.
Okay. Do you know of any
It's the firework. It's hearing the bang and seeing the flash sparkler, like whatever the underneath the door. Like somebody would have to be over there. Like that was the whole purpose of that. Is that somebody didn't leave out the back, that they left out the front. And then Dylan saying that she heard it when Bethany was interviewed.
do you know of any romantic relationships within that house? And if you listen to any of the Chris Whitcomb interviews, he had also somewhat alluded to there could have been some sort of hooking up going on with people in that house when it came to, was it Bethany and Ethan? And he had said, not that combo.
Not that combo. So I think there's something to that trifecta that but do I have anything specific? No, but people do not do what they did to Ethan if they are not jealous and do not hate them. So whomever that was either loved Ethan or hated him.
Okay. That makes sense.
Does that make sense? Because the injuries that Ethan, I believe is, he was a fresher. I had a fresher too. No big deal. They just need 5 years. So he had, he was working his way back and he really wasn't a fan of, my understanding is, and I had only seen Ethan a couple of times. My kid played against him basketball and he's a nice kid. He's a nice kid. He's not an aggressive kid. In the heat of the moment, actually, this might matter. Hunter and Ethan were on the same team, and my son and his cousin were on the same team. Well, Hunter and my nephew didn't get on very well, and they played the same position, and so they kind of got into it. And so Will's pulling back John, and Ethan's pulling back Hunter, and both Will and Ethan are laughing, and it was like, oh, So to watch him play, it wasn't like the end of the world. It was like my kid. It was like, this isn't like this. So that may give an insight to anything they say about him being aggressive to anybody is not. I couldn't see it in the heat of the moment. That's
Okay.
what that's I'm saying. That's all I mean by that. But he's I do think that somebody loves Xana, and she tutored him the year prior, maybe. And Ethan came on, and maybe, and I think he was in a jealous rage.
Okay.
And I think his hair matches the hair in his hand. And that's my opinion. In my opinion, everybody, nothing to base that on, just from being a mom.
Okay.
Seeing a kid play 2 ball games.
Okay. Next couple of questions. There are people asking, do you know what Maddie told Adam?
I wish I did. I don't.
Okay. What are your thoughts on Jack, Dee, and Dylan in general? Those 2 individuals.
I don't, they're kids. I think that as far as their guilt or culpability, I think Jack probably had a feeling something was going to go down. I don't think he thought this. I don't think he was involved in it in any way. I think he would have stopped it if he'd known. I think that his phone was taken by Adam from him, and there's like, she's just a bee, leave her alone. I believe that's the truth. That they were saying, you're just heartbroken or whatever. Meanwhile, knowing something different, but he wasn't sleeping. There's no question of that. He is the first person to offer up his DNA, everything, his phone, whatever they wanted. Do I believe he has any guilt? No, maybe some knowledge, but I believe he would tell Steve everything he could.
Okay.
And he's heartbroken. In my opinion, that's what I think.
So is there, moving on to another question, and like I said, I just kind of want to rapid fire.
Okay.
As far as Dylan and Bethany and the 8-hour delay, do you believe that they were, I know you'd said they maybe were locked in the closet, but do you believe that they were forced to stay there? They were told to not call for a certain time?
Well, they locked themselves in the closet. I'm sorry if that wasn't. They weren't locked in a closet. They locked themselves in the closet.
Okay, and you believe that was the closet in
Bethany's room, but nobody's ever. It said down in the downstairs roommate. So,
yeah.
But I guess there's 2 rooms down there, right? So who knows?
Well, there is, and where my head's going, if you listen to Chris Whitcomb, is he said that spare bedroom is going to become important, and there's some sketchy stuff in there, and that is where the blood on the jacket was found. That's where people.
I think it was on the club, and Dylan was a golfer too.
Interesting.
I think the glove was part of it. Yeah.
Do you think that Dylan and Beth, so the cleanup? Do you believe that the girls were forced to help clean up, or do you think that other people cleaned up?
Well, I question why. So this is what I question, knowing my kids. She went outside. It was cold. It was 17 degrees that morning. She goes outside, and she's got wet hair with French braids, weird hairdo in college. Now these days anyway, and no shoes. I don't know a girl on Greek Road that doesn't own at least 4 pairs of Uggs. Were her ones by the door destroyed with blood? Who knows? Maybe. Outside, right?
Yeah, I see what you're saying.
So Bethany seemed to be more composed, but I think the cell phone records say that Dylan was on the phone with her mom from 10 on.
There was a lot of phone activity, as we know. And so I guess with the surviving roommates in your head, do you think that they actually had anything to do with the killings?
I other than knowledge, I don't know. I would never, nobody, I don't have proof that they would, or,
Okay.
you know what I mean? But do I think they know what happened? Absolutely. They're not idiots. These houses aren't that big. They're
Right.
actually really small.
Well, and I don't just want to ask you, all the same questions that really it'd be. And
Oh,
this,
it's whatever you want to
to,
ask.
but it'd be there's questions that I feel like everybody's wondering, and it's not like you're gonna have some crystal ball and know everything about it either. I'm just kind of throwing some of them out there. And Lauren Lovely had asked, and thank you, Lauren Lovely, for the super chat. Said, "I'm sorry if WSU mom answered this. Here is some support nonetheless. Thank you. But what was the 17-minute conversation about where Kaylee and Jack spoke on the phone?" So Jack actually called Kaylee.
I don't know.
Okay.
I think they want us to believe it's about Murphy, but it's too coincidental because she was typing like on fire, texting, right? That
She
like on fire.
back to back. Yeah.
Yeah. So, it could be just two kids breaking up.
Okay.
I don't know. That's why I can't answer that with any information.
DJ Frankie Fitz, again from Ireland, said the hair found with Ethan and on Maddie's bed. So as we know, there's a clump of hair found in Ethan's hand. They didn't test the quote unquote debris. There's also hair found in Maddie's bed by her and Kaylee. I heard you briefly talk about the same length of somebody's hair that you believe was found in Ethan's hand.
Yeah, I think it's one of the fraternity brothers' hair.
What was that?
I think it is one of the people in. So it looks a lot like Barachola's hair,
Okay.
but it could be Jack's hair too. But that yellow, that gold, right? Almost red. It's like you would think it was Murphy's right at first, but it's not. It's not Murphy.
And Kim, I don't want to hold you hostage either here.
You're not. You're
Okay. So is there anything, I don't just want to keep saying, is there anything that you've heard that you haven't said? But I guess one of the things that I've always wondered about too is in the beginning,
Mm-hmm.
and when kids talk, there must have been one rumor that made its way to being the most talked about or the most theorized onto what happened. I mean, if you watch even the mainstream media documentaries, these people are like, well, yeah, we were all sitting around talking about like who could have did it or this is what we think.
Mm-hmm.
Was it the shakedown for you?
It was, you know what? It was the lack of fear, right?
Okay.
Because they didn't have any, so they knew it was targeted, right? I mean, that's all I could assume. I said, whatever happened it was only going to be them. It wouldn't be like my daughter said, like screamed at me. It wouldn't be Will and I. It just wouldn't. And I'm like, that. How do you know that? And she said, I just do, which only leads me, and I can't push her too much, right?
Mm-hmm.
Because I know she didn't do it. She wasn't present, and I can only get her to. But I know she wouldn't leave parents and families hanging. I know my kid, but anyway, now I went off the trails again. But
no, you're fine.
But anyway, so did I answer the question?
Yeah. So I was wondering,
what do I know? Oh.
Well, not what do you know, but I was just curious as far as in the beginning when the kids were talking, what was the rumor that bubbled up right away? Because I feel like as kids are talking, right, you talked about the Snapchat. It was like, oh my God, 4 kids were stabbed. Was there an initial like, this is what happened?
That was it.
It was okay. So that
They
you had
never
heard.
talked. They really rarely talked about it unless they were like at my house, because a lot of times they would come to our house to the airport. So we had them quite a bit. And yeah, they would talk to me because I was sitting there listening and just listen and, and report whatever I heard that. Well, I reported everything, but no, I wish there was something because I would tell you because that would lead us there faster. We'd get a resolve faster. The rumors are that that's where you go if you're going to buy. It's a party house. Pullman really stopped going there about 2 or 3 years ago, because of well, they never went to the corner club, and I didn't ask her why, but obviously she knew better. And they had a lot of stuff on trafficking, a lot of it, for as far as programming goes. Do I think there's a trafficking thing? Probably. I do think that was what they were going to do with Maddie, and that was going to be a lesson not to owe the money again.
Okay, so I see. Essentially, your story has stayed very, I guess, similar throughout this, right? I mean, there's rumors going on campus. There's going to be a shakedown. There's drugs involved, and then, outside of the little details, really, one of the most profound things that I've heard you say is that you believe Jack Showalter was smoking a cigarette outside and was forced to do something so that he couldn't snitch.
Mm-hmm.
I can't believe. I mean, that's just crazy. And so, Hive, help me out. I mean, as far as questions, I feel like I threw a lot at Kim. Is there anything that I didn't answer, or is there anything that, I mean, and think about something that Kim might actually be able to help with too.
Right. And I just want to be, and here's the thing. I will never, ever tell a lie intentionally or an untruth intentionally, and always apologize if I'm incorrect about something. All I have is the knowledge I have, and most of it has been proven to be true over time, right? So I trust, and it's not me, it's the kids I'm speaking for, not myself. It's what they're telling me that I'm just turning around and sending to the authorities.
Do you believe the cops are involved?
Yes.
Not just in the cover-up?
Yes. I believe the owner of the home is involved, not just in I mean, that white car, I'm sorry, there are not coincidences like that. That's crazy sauce. The owner of the home also owned the wrecked white car in Oregon. Sorry, that's too coincidental. That's crazy.
Have you read Broken Plea yet or no?
I've started it. Yeah, I've started it. I just got it in. So I have started it. But
what about a lot of people will bring up Dylan's quote unquote boyfriend Quinn? Anything on that?
I have many, many questions about Quinn and his father and his uncle, who's in prison for murder right now, who's arrested over between this time frame, or not arrested, but maybe sentenced. I don't. But yeah, I do. He comes from a very violent background.
Okay, another question that's coming up a lot. I'm just kind of glancing at the chat, seeing what is flying by. One of them also had talked about it. Was it live streamed? And I had asked Chris Whitcomb this. Obviously, he's the author of the book Broken Plea. He said no, and he said it rather quickly. Did you hear that rumor from just the general community, or did you actually hear that ever from somebody directly that might have more, I guess, insight for boots on the ground? They heard this.
Well, I'd actually need my notes at that point for that, because I would have written down where I didn't have any problem calling the school and the people in the offices and admin at all. I mean, honestly, I'm paying you, the president of the school, you need to call me back, because, you got my kid's future in your hands here. What's going on? So it's probably somebody, I'll have to look before I give you the name. I'm sure I have it.
As far as it may have been recorded, live streamed.
Oh, I don't believe I saw it live stream.
Okay. Well, Kim, honestly, I could keep you up here all night and ask a bunch of questions. I now feel like we're kind of getting a little bit into the weeds of the question, but and we're already at 2 hours. I wanted to just say thank you so much for popping up tonight and being willing to share that. Obviously, I've seen your name in the chat a lot as I'm live. So, call-in shows or anything else, or, my email is birdieshivemind@gmail.com. Please don't hesitate to reach out if you have anything or hear anything, or if you know anybody that wants to, come on the stream and talk about it. We're more than happy.
Yeah, God damn it, Birdie. I want to come on the stream and fucking talk about it. What the fuck? Birdie just texted me. He's like, Yeah, quite the live stream tonight, huh? I said, quite these titties, huh? Yeah. Quite these titties, Birdie. Quite these titties. Wow. What a night. This just came out of nowhere. Birdie, should I go back? What time does she come on at?
So then I, of course,
Oh.
called my gut
Wow.
implement and
Well, wow.
and just asking questions and not cover up or something.
Oh,
So
wow. I thought it was
Ken Maines, I think is his name, and both of them said the exact same words: "Get him the fuck out of there." That's exactly what they said, and I took their advice.
And I don't want, and I don't. It's said crime scene cleanup first, dispose bodies. I think you might have left a comment on one of my. Yes, your mom. I'm going to the shortly.
At the time, and my daughter was one of the students who received a Snapchat at 10:30 a.m. So as it was Parents Weekend for Wazoo, my husband and I were at Wazoo with our kids and had no clue what happened in Idaho. We were on our way home about 4 o'clock in the afternoon on that Sunday, and we got a Coug alert, which is like a vandal alert. They're the same thing. That's just what they call them. And it was like 5 o'clock or so. Well, clearly they were waiting until the parents left campus because, I would have taken my kids and packed them up and put them in my Denali, and I would have taken them home right there. And I think all of us parents would have with that kind of a crime, right? Because none of us knew anything. And my daughter didn't tell me anything because she just got a snap. And here's the thing, she loved college. She was a senior.
Kim? Oh. Okay, she just dropped off. I'm going to drop the link again.
Okay.
Slow the chat down. So let me, 1 second.
I don't know where I was stopped at, but
No,
I don't.
We're gonna have to discuss this tomorrow because everybody knows that I know Kim. I've talked to Kim for a long time. I've vetted Kim. Kim 1000% gave me free reign of her phone records. She 1000% made all the phone calls that she said. I went through all of them. She is exactly who she says she is. Her kids go there. Like all of that shit's 1000% true. She called the feds. She called and it was immediately when it started. It wasn't like, midway through this case or something like that. And no, I've looked at her phone records, so I can honestly say that without a doubt, I have vetted Kim calling I need to ask her. I need to ask her what authority she talked to specifically, because I want to put a FOIA request in and I want to see if I can find, they should have a report of talking to this woman, because that would be a report that would go to the defense. You know what I mean? Especially the big things, which is the snaps. Those snaps were everything. The 10:30 in the morning, 10 a.m., 9:30 a.m. snaps of it already being talked about in Snapchat. And it's exactly what Dylan was doing that morning, in Snapchat. It ends up being true. Dave said it was. It happened. Whatever. I know that she went and did, like I said, I gotta talk to her. I gotta talk to Kim. Go Cougs. Yeah, we're gonna talk about it all. We're gonna call it a night right now. I can't get into my mindset we're just gonna leave it right here. Really, Birdie on the screen right there. We're all gonna say happy Cinco de Drinko. Hopefully everybody had a great night with Cinco de Mayo. Woo! Yeah. I want to thank the moderators for modding tonight. I want to thank the subscribers for being in here. I want to thank the lurkers. I want to fucking thank everybody. I want to thank Birdie for being on the screen. I want to thank all of you guys that are members. I want to thank Allie Tally, who bought 10 people memberships and who's always buying people memberships, making you part of the alien crew over here. I want to thank Gare Bear over there at WSU. He's a fucking gem. That bubbly fuck. Thank you. All right. Yeah. We'll see you guys in the next one. We'll see you tomorrow. We'll see you tomorrow, where I'm going to be pointing out things on page 94 and 95 of the book, because we're really going after this timeline, and we're really going to talk about Ethan's white socks. We're going to talk about all of Xana's bedroom. I went through and I just took out the pictures that only focus on Xana's bedroom and focusing straight and strictly with every little thing that was Ethan's in that room. I don't care about anything unless it's fucking Ethan's. And so yeah, we're going to talk about page 93 and 94 of the book. Again, I'm just curious if people are bedtime sock sleepers. I don't go to bed with my socks on to go to sleep. Okay, and Kaylee wasn't one. Kaylee had her socks on. That tells me that Kaylee was not geared up and ready to go to bed. Okay, if she was geared up, ready to go to bed, those socks would have been off. I got confirmation that Kaylee was not a bedtime sleep sock wearer, so it matters. And I'm just curious if Ethan was. And yeah, okay. No socks here, no socks. All right, until tomorrow, guys. Come deep dive. See you later. Thank you so much. Be kind.